Has the president ever disavowed his campaign statements? Has he ever stood up and said, I said before I wanted to ban all members of the Islamic faith from entering the United States of America. I was wrong. I've consulted with lawyers. I'm now addressing it simply to security needs. Has he ever said anything approaching that?
Yes, Judge Hawkins, he has said several things approaching that, and I think it's detailed in various amicus briefs. The best one is probably the Southeastern Legal Foundation brief, and Part 3 walks through the comments and shows that over time the president clarified that what he was talking about were Islamic terrorist groups and the countries that shelter or sponsor them. And over time, he and his advisors clarified that what he was focused on were groups like ISIS and Al-Qaeda. And really, the one post-inauguration statement they've got, the we all know what that means, I'd encourage the court to go back and look at the ceremony in which the president signed that executive order.
The second one.
Well, that's the first one, right? They don't have anything on the second order. Right. But even if you said, okay, that's the first one and we'll carry that through, which for various reasons we've said you shouldn't.
What about the statements where his surrogates have said the president is simply carrying out his campaign promises on this issue?
But that's true, Judge Hawkins, because during the campaign he clarified that what he was talking about were territories and countries that Congress and the previous administration had determined were dangerous. And what he wanted to do was, he said, increase the vetting procedures. And that's what he said 3 minutes before he signed the first order, standing there next to the newly sworn-in Secretary Mattis.
Sounds like you argue that our approach to these statements should be sort of an abuse of discretion review. If you could read the statements, good or bad, we should defer to the good.
I think the value of the Mandel standard is that
you don't look.
Is that courts don't start engaging in this, but if you do, and for the reasons we've said in our briefs, we think as a matter of law you shouldn't. But if the court were taking them all into account, and here I mean not just the post-inauguration official capacity statements, but the campaign trail stuff, we would still say, look, the president clarified over time, and in the face of ambiguity about that, both respect for a coordinate branch and the presumption of regularity would require not reading them, I think as the district court did here, in the light most hostile and least favorable to the president.